The people at the not-for-profit Citizens United were on a mission. They hated Hillary Clinton a lot. They filmed what they called a documentary, Hillary the Movie, and planned to release it in 2008 in an effort to submarine her candidacy for the Democratic Party nomination for the presidency. They wanted to air their hit job film just prior to primary elections in the various states, but they had a problem. One of the provisions of the 2002 Bipartisan Campaign Reform Act, commonly called McCain-Feingold, banned the airing of corporate-funded electioneering communication for the 30 days before a primary election and for 60 days prior to a general election. The Citizens United people wanted to blanket the airwaves with their electioneering communication attack piece all the way through the primaries. So in December 2007, they filed suit to challenge that provision of McCain-Feingold. If they won, they would be able to run their electioneering film in the then upcoming campaign season of 2008. The district court refused their application for injunctive relief. In the appeals court, Citizens United claimed their 30-minute film was a documentary, not electioneering. The courts easily saw through that smokescreen and refused their argument, stating what was perfectly clear to everyone, that it was not a documentary film, but a 30-minute attack ad. It was an attempt to affect the election, the very definition of electioneering. Further, the court saw that their intended use of the movie was expressly at odds with established law. On the case went to the Supreme Court, Citizens United versus the Federal Election Commission, which decided in favor of Citizens United in January 2010, overturning the lower court's ruling. The court declared that the corporate electioneering communications restrictions of McCain-Feingold were unconstitutional, and Citizens United could air their film as they wished. That should have been the end of the case, but it wasn't. Chief Justice John Roberts directed the attorneys to return to the court and re-litigate the case, this time specifically testing the rights of corporations and speech equivalency. It's important to note that those issues were not part of the case brought by Citizens United. In other words, the court fabricated an entirely new case focused on issues that were not in contest in the Citizens United case. That is not supposed to happen. And in this fabricated case, the Supreme Court decided in a 5-4 vote that corporations have full First Amendment rights. Let me be clear about this. The court majority effectively declared that non-sentient, non-human corporations have all the rights of flesh and blood human beings, like you. Making things worse, Justice Anthony Kennedy, writing for the majority, reaffirmed that money was effectively the same as speech. He declared that the First Amendment doesn't allow prohibitions of speech even if the speaker is a corporation. And that started a deluge of corporate money, dark money, into our politics that persists today. To be sure, there were earlier cases that chipped away at our protection from big money influence on our politics, including Buckley v. Valeo, which effectively declared that money is the same as speech. That assertion, of course, is ridiculous. While money used for a campaign contribution, for example, certainly enables speech, it doesn't make it the same as speech. Indeed, if you follow the court's Buckley logic, they'd have you believe that if I use money to buy a car, that money is the same as a car. Utter nonsense. Money is property that is used in exchange for other things. That doesn't make it the same as those other things. Nevertheless, the Roberts Court wasn't able to or refused to see the difference, and the Citizens United case became the backbreaker of integrity in our elections. Key point. That decision was driven by John Roberts legislating from the bench in a case that was not even brought before the court by a plaintiff. One has to wonder if this was a predetermined decision he wanted to reach. Otherwise, where did that secondary case come from? Put a bookmark there. Professor Heather Cox Richardson reported this in her July 6 edition of Letters from an American. Both the Organization of American Historians and the American Historical Association, the flagship organizations of professional historians in the U.S., along with 8 other U.S. historical associations so far, yesterday issued a joint statement expressing dismay that the 6 Supreme Court justices in the majority in the Dobbs v. Jackson women's health decision that overturned Roe v. Wade ignored the actual history of those organizations provided the court and instead adopted a flawed interpretation of abortion criminalization. These misrepresentations are now enshrined in a text that becomes authoritative for legal reference and citation in the future, an undermining of the imperative that historical evidence and argument be presented according to high standards of historical scholarship. The court's majority opinion does not meet those standards. Translation. The Supreme Court ignored evidence that was inconvenient to the decision the justices wanted to make, that is, overturn Roe. As in the manufactured case derived from the Citizens United lawsuit, the court clearly had its mind made up to push the doctrines it wanted, irrespective of precedent, facts, and even without a case before it. And that radicalization is the true danger of this gerrymandered Supreme Court. It appears these justices want to roll back progress 90 years. Are you seeing the pattern yet? You better see it, because this court has already invited yet more cases to give them the opportunity to end yet more rights of the people. For further reading, review Harry Litman's troubling forecast of Supreme Court malfeasance in the linked New York Times article. Special note. According to an ongoing Gallup survey, public confidence in the Supreme Court has plummeted down to 25%. And this study update was conducted before any of the end-of-term court decisions were announced, including Dobbs. A fresh study will almost certainly show a sharp drop from the already historically low public confidence in the court. A similar drop in confidence is what Justice John Paul Stevens predicted in his blistering dissenting opinion in the Citizens United decision in 2010. You can see both drops in confidence in the graph in the written post. I'm Jack Altshuler.